in which the Supreme Court states that Article 14 is the genus. Article 14 is the genus, where Article 15, 16, Article 16, 17, 17, and 18 are the species. Article 14 deals with the genus, that is the genera of the right to equality. It speaks the genera of the right to equality, or general சொல்லுது. 15, 16, 17, 18 எல்லாம் வந்து ஸ்பெசிபிக்கா சொல்லுது. புரியுதா? அதனால சுப்ரீம் கோர்ட் ஆர்டிகல் 14 as genus, 15, 16, 17, 18 are the species that conferring the right to equality. Article 14 நமக்கு என்ன தெரியும்? Article 14, that is அதனுடைய dimension. The dimension of Article 14, அது தெரியணும். Next, Article 14, the core of Article 14. What is the core of Article 14 and significance? இது மூணு தான் நமக்கு தெரியும். What is the dimension? எப்படி Article 14 enumerate பண்ணிருக்காங்க? The dimensions of Article 14. One is equality before law. One is the equality before law. Equality before law. Next dimension, அந்த நாணயத்தினுடைய இது equal protection of law. Equality before law and equal protection of law. இது Article 14 உடைய dimension. Equality before law, அது legal dimension. Legal dimension, it is called as juristic equality. Juristic, a juristic equality. சமத்துவம் என்பது நீதியின் அடிப்படையில், நீதி தேவதை கண்ணில்லாதது, அது எல்லாமே ஈக்குவலா பார்க்கும். சட்டம் என்ன சொல்றோம் அதுதான் பார்க்கும். கண்ணில்லாத நீதி தேவதை. Juristic equality, that it states that all men are equal before the eyes of law. அது legal dimension. All men are equal before the eyes of law. ஒரு இங்கிலீஷ் கான்ஸ்டிடியூஷன் திங்கர் அது சொல்லுவார், all men are equal before the eyes of law. All men and their actions are amenable in the court of law. All men are, their actions are amenable in the court of law. Where it states that you may be so high, but the law is above you. You may be, எவ்வளவு பெரிய ஆளா இருக்கலாம், may be so high, but the law is above you. Law is above you. Any authority, right from Prime Minister to the Constable, right from Prime Minister to Constable, shall answerable for their actions. Their actions has to be amenable in the court of law. The law is above you. Any from Prime Minister to Constable, all their actions should be conferred to the law. Their actions should be authorized by the law. Their actions to be authorized by the law. That is, where it states lex rex. Lex rex. King is the law is the king. Then rex lex. King is the law, and lex supremus. Law is supreme. Lex supremus. The law is supreme. That is a legal juristic dimensions of Article 14. புரியுதா? Juristic dimensions of Article 14. ஒரு சில எக்ஸம்ஷன். எல்லாரும் வந்து சட்டப்பிரகாரமா ஃபாரின் பிரசிடென்ட் அந்த கவர்னர்ஸ், தேர் ஆல் தி கான்ஸ்டிடியூஷனல் அத்தாரிட்டிஸ். எல்லாருக்கும் பொதுவா சட்டத்தின் முன் அனைவரும் சமம் மட்டும் அவங்களுக்கு இது பண்ண முடியாது. அதே மாதிரி ஃபாரின் டிப்ளமேட்ஸ் அவங்களுக்கு அப்ளை. So எல்லாருக்கும் பொது அது legal dimensions, juristic dimension. Whereas the equal protection of law, அது வந்து reality conditions. If the law, if a law uniformly applied to, if the law uniformly applied to different, applied to the social groups of inequality, the social groups of inequality, it would be harmful. Yeah, it would be harmful. Equal protection of law deals with, equal protection of law deals with a dynamic equality, a dynamic equality that is realistic. It comes from the US traditions. It comes from the US traditions. Whereas the equal protection of law, that means equal treatment in equal circumstances, equal treatment in equal circumstances, equal treatment in equal circumstances, equal treatment in the equal circumstances. That means a like treated, a like treatment, a like treatment, a like treatment of like groups, a like treatment of like groups, a like treatment, a like treatment, a like treatment of unlike groups. Unlike groups cannot be accepted. The social groups may be, the social groups are known for inequalities. Social groups are known for the inequalities. A law which enforceable uniformly on the groups of different standards would be harmful. The law become harmful. So equal protection of law deals with equal treatment at equal circumstances. Equal treatment of the equal circumstances. So the law requires classifications of the classifications. The law requires the classifications of the social groups. Classifications of the social groups. Classifications of the social groups to have the equal protection. The groups are to be classified. இப்போ வந்து ஒரு பப்ளிக் டாய்லெட் கட்டுறாங்க, பப்ளிக் டாய்லெட் கட்டுறாங்க. இப்போ ஒவ்வொரு காஸ்ட்டுக்கு ஒரு ஊர்ல பப்ளிக் டாய்லெட் கட்டுறாங்க. இப்போ ஒரு ஹையர் காஸ்ட்டுக்கு ஒரு பப்ளிக் டாய்லெட், லோயர் காஸ்ட்டுக்கு ஒரு பப்ளிக் டாய்லெட் வந்து வந்து நியாயமா? லீகலா இல்லீகலா? ஹலோ
சார், இல்லீகல் தான் சார்.
இல்லீகல். ஏன் இல்லீகல்? டிஸ்கிரிமினேஷன் இல்லையா? இல்லையா? ஆனா பப்ளிக் டாய்லெட்ட மென் உமனுக்கு தனித்தனியா கட்டுறாங்க. லீகலா இல்லீகலா? ஹலோ, லீகலா இல்லீகலா?
சார், லீகல் சார்.
லீகல். யா, இது கிளாசிபிகேஷன். புரியுதா? புரியுதா? It is the classification of the social groups.
இன்னொரு முறை கொஞ்சம் சொல்லுங்க சார், சரியா புரியல சார்.
இப்போ பப்ளிக் டாய்லெட் வந்து ஹையர் காஸ்டுக்கு ஒரு டாய்லெட், லோயர் காஸ்டுக்கு ஒரு டாய்லெட் ஒரு ஊர்ல கட்டினா அது நியாயம் இல்லையா? இல்லீகல். ஆனா டாய்லெட் வந்து உமனுக்கு தனியா மென்னுக்கு தனியா கட்டினா நியாயம் இல்லையா? ஏன்னா இது கிளாசிபிகேஷன், இது வந்து டிஸ்கிரிமினேஷன். That is the classification of the social groups. The law has to apply like treatment for the like groups. Like treatment for unlike groups is not valid. Is not valid because the law would become harmful. இப்போ சிட்டிசன்ஷிப் அமெண்ட்மெண்ட் ஆக்ட் வந்து எப்படி கிளாசிஃபை பண்றாங்க எப்படி கிளாசிஃபை பண்றாங்க religiously persecuted minorities. இது மேல இருக்கிற கிரிட்டிசிசம்னா சிட்டிசன்ஷிப் அமெண்ட்மெண்ட் ஆக்ட்ல மேல இருக்கிற கிரிட்டிசிசம் என்ன? இது கிரிட்டிசிசம் என்ன? It violates equality of religion. இல்லையா? It violates the equality of religion. ஏன் முஸ்லிம்ஸ் சேர்க்கல? அதானே? ஏன் முஸ்லிம்ஸ் சேர்க்கல? அதானே? இப்போ ரிலிஜன் முஸ்லிம் என்ற பேஸ்ல தான் பார்ட்டிஷன் நடந்தது. கரெக்டா? முஸ்லிம் என்ற பேஸ்ல தான் பார்ட்டிஷன் நடந்தது. ஓகே. செகண்ட் வந்து ரிலிஜியஸ் பெர்சிக்யூஷன் ஆஃப் நான் முஸ்லிம்ஸ். அதானே அங்க ரிலிஜியஸ் பெர்சிக்யூஷன் ஆஃப் தி நான் முஸ்லிம்ஸ். இப்ப கொஸ்டின் என்ன, முஸ்லிம்ஸ் சேர்க்கல, ஷியாஸ் வந்து அங்க பெர்சிக்யூட் ஆகுறாங்க, அகமதியாஸ் பெர்சிக்யூட் ஆகுறாங்க. அதெல்லாம் if the problems of Muslims within the Muslims has to be fixed by the Muslims, not by the state of India. Not by the state of India. The secular state of India applies the Citizenship Act by the reasonable classification of non-Muslim minorities. Purida? Non-Muslim minorities, because for two reasons. Because it is the partition made on the grounds of Muslims and they were considered themselves as the Muslim states. Purida? Hello? இப்ப முஸ்லிம் செக்டுக்கு பெர்சிக்யூஷன் நடந்தான்னா முஸ்லிம் ஸ்டேட் அது, அவங்க கிட்டதான் சொல்யூஷன் இருக்கு. ஆனா இந்த நான் முஸ்லிம்ஸுக்கு வேற சொல்யூஷன் அங்க இல்ல. புரியுதா? நான் முஸ்லிம்ஸ்க்கு அங்க சொல்யூஷன் இல்ல. செகண்ட், இந்தியாவுடைய ரெஸ்பான்சிபிலிட்டி ஆன் த எத்னிக் origin, ethnic common origin. Before 1957, they were all the ethnically part of India. அவங்களுக்கு இருக்கிற ஒரே அசைலம் இந்தியா தான். புரியுதா? This is classification. புரியுதா? This is classification. Muslim minorities வந்து இதுல சேர்க்க முடியாது. Because this classification is reasonable. This classification is reasonable. It is reasonable classification. எப்படி இருக்கணும்னு சொல்லுதுன்னா Article 14, the classification should be reasonable. Supreme Court described this classification should be on the ground. This classification should be on the ground, on certain grounds of time, geography, time, time and the geography. Then this classification should not be arbitrary. இஷ்டத்துக்கு பண்ணக்கூடாது. Classification should not be arbitrary. This classification should have a procedure, a test of procedure, that this classification should have the test of procedure. That procedure represents the test of procedure. that represents this classification should be என்னென்ன டெஸ்ட் இருக்குன்னா should have the nexus between the classification and the objectives sought to be achieved, and the objective should be achieved. அந்த இந்த வகைப்படுத்துறதுக்கு எதுக்காக வகைப்படுத்துறோம்ன்றத அப்ஜெக்டிவ் இருக்கணும். தட் அப்ஜெக்டிவ் should be rational. எதுக்கு சோஷியல் குரூப்ஸ் வந்து டிப்ரெஸ்ட் கிளாஸஸ், உமன், சில்ட்ரன் எதுக்காக நியாயப்படுத்துறாங்கன்னா டு அச்சீவ் சோஷியல் ஜஸ்டிஸ். தட் அப்ஜெக்டிவ் should be rational. புரியுதா? This classification should not violate the principle of natural justice. இதெல்லாம் சேர்ந்து வரணும் கிளாசிபிகேஷன். ஓகேவா? பிரின்சிபிள் ஆஃப் நேச்சுரல் ஜஸ்டிஸ் இதுதான் உங்களுக்கு ஆர்டிகல் 14ல நீங்க தெரிஞ்சுக்க வேண்டியது. Article 14. What is the significance of Article 14? Significance of the Article 14. Significance of Article 14 was the two one. One is Article 14 enshrined the principle of rule of law in the Indian Constitution. Rule of law in the Indian Constitution. Rule of law, Supreme Court observed that the rule of law is one among the element of basic structure. One among the element of the basic structure of the Indian Constitution. One among the element of the basic structure of the Indian Constitution. This rule of law implies three aspects. One is equality before law. Rule of law means it should have the equality before law, then equal protection of law. Equal protection of law, and the law is supreme. So Article 14 is also supreme. And Article 14 is one among the element of basic structure. Article 14 constitutes a golden triangle of the fundamental rights. Supreme Court stated that the entire fundamental rights revolves around the three articles. One is Article 14, then Article 19, Article 20. So any 21, Article 21, any classifications should fulfill the principles, the provisions that enshrined in Article 21 and 19. Enshrines in Article 21 and the 19. So this embodies Article 14 of the Constitution. Okay? Okay, va?
Hi, sir.
Okay, Article 14, nodia dimensions. Article 14, nodia dimensions. Article 14, nodia significance. Article 14, nodia core வந்து rule of law. Article 14, nodia core வந்து rule of law and significance, that is rule of law and a part of the golden triangle of the court. Okay. Then Article 15. Article 15, which states that the state shall not discriminate any individual only on the grounds of religion, race, sex, or place of birth. Only on the grounds of religion, race, sex, caste, place of birth, or any of them, or any of them. Article 15 plus 1 is the prohibitions imposed on the state. Article 15 plus 1 was the prohibitions imposed on the state. State மேல ஏற்பட்ட தடைகள். That means state shall not discriminate. State shall not discriminate. State shall not discriminate any individual only on the grounds of religion, sex, place of birth, caste, race, and any of them. Whereas Article 15 clause 2 is the prohibition imposed on other citizens, that is individual, which states prohibition imposed on the citizens. இது வந்து அரசுக்கு மேல 15 clause 1 அரசுக்கு மேல போட்டப்பட்ட தடைங்க. ஆனா 15 clause 2 வந்து தனிநபர் குடிமகன்களுக்கு மேல போட்டப்பட்ட தடைங்க. That means no subject, no citizen shall be subjected to any form of disabilities. Any form of disabilities on the grounds of religion, race, sex, place of birth, any form of disabilities in access to public restaurants, shops, hotels, places of public entertainment, village ponds, village resorts, public resorts, village ponds. That is Article 15 plus 1 is the obligations of the state, whereas Article 15 plus 2 is the obligations of the citizen. Is the obligation of the citizen. புரிதா? யாருடைய obligations, இந்த ஆர்டிகிளினுடைய இம்பார்ட்டன்ஸ், யாருடைய obligations. Then next, it is grounds of discriminations. That means grounds of discriminations are race, religion, sex, race, religion, sex, caste, place of birth, or any of them. Place of birth or any of them. Place of birth or any of them. இதுல எந்த ஒரு discriminations இருக்கக்கூடாது. That means grounds. That means which implies that the state can discriminate in other grounds. State can discriminate in the other grounds. The state can discriminate in the other grounds. Other grounds, அது என்ன சொன்ன, state in the grounds தவிர the state can discriminate the other grounds. Other grounds that was stated in the exemptions to the article. Other grounds that was stated in the exemptions to the article. Exemptions to the article as the Article 15 plus 3. Article 15 plus 3. Article 15 plus 3, which states that the state shall confer the special privileges. The state shall confer the special privileges. The special privileges for women and the children. Can confer the special privileges for the women and the children. Then the Article 15 plus 4, which states the state shall confer the special privileges for the depressed classes. Then Article 15 plus 5, state shall confer the special privileges for the socially and educationally backward classes. Socially and educationally backward classes. So entire Article 15 deals with the issue of non-discrimination, issue of non-discrimination, non-discrimination. And entire Article 15 உடைய conscience, the conscience of Article 15 என்னன்னா, to differentiate between the conscience of Article 15, the conscience of Article 15 is to differentiate between the discrimination and classification. புரியுதா? The entire Article 15 உடைய core என்னன்னா, to differentiate between discrimination and classification. Article 15 clause 1 and clause 2 deals with no discrimination. புரியுதா? No discrimination. And 15 clause 3 clause 4, 15 clause 3 clause 4 deals with classification, deals with the classification, where 15 clause 3 clause 4, which states state shall states that state shall confer some classifications. அதுல முக்கியமானது classifications to promote justice, to promote a progressive equality. அதுல முக்கியமானது right to education act. Right to education act வந்து சிறுவர்களை classify பண்ணுது with the age group of 16 to 14 to have the universal age, to have elementary education as a fundamental right up to class 8. Elementary education as a fundamental rights up to class 8. State shall provide the free and compulsory education. State shall establish a neighborhood school. A neighborhood school என்றது ஒரு 2 கிலோமீட்டர் உள்ள இருக்கிற எந்த ஸ்கூல், both public and private, should ensure compulsory admission, assistance and completion of that elementary education, completely on the elementary education. By that, to establish progressive. Article 15 உடைய core என்னன்னா, discrimination and classification வகைப்படுத்துறது. புரியுதா? discrimination and classification வகைப்படுத்துறது. ஜெனரலா வந்து அரசு வந்து வேற்றுமை பார்க்க கூடாது, அதுக்கான கிரவுண்ட்ஸ். ஆனா 15 clause 3 clause 4 clause 5 வந்து அரசு வந்து வகைப்படுத்துறதுக்கான சில சோசியல் குரூப். அது யாருன்னா, உமன் சில்ட்ரன், depressed classes, socially and educationally backward classes. அதுல அந்த ஆர்டிகல் 15 பேசிஸ்ல இயற்றப்பட்ட முக்கியமான சட்டம் வந்து the Right to Education Act, Right to Compulsory Universal Education Act for the children's. Okay, for the children's. Then Article 16, which deals with the non-discrimination, that is the non-discrimination of the state shall not discriminate any individuals in public employment, Article 16 clause 2, Article 16 clause 1 and clause 2 ensure the non-discrimination of individuals on certain grounds. They are religion, race, caste, sex, descent, place of birth, residence, இதெல்லாம் ஆர்டிகல் 15ல இல்ல. Descent, place of birth, residence, or any of them for individuals, for the individuals in the public employment. Article 15, Article 16, clause 2, clause 1 and clause 2. என்னாச்சு இதுக்கு? Article 16, clause 1 and clause 2. Article 16, clause 1. Article 16, clause 1 and clause 2 deals with the non-discrimination of the individuals on certain grounds in the public employment. Non-discrimination of the individual on certain grounds in the public employment. That means non-discrimination on certain grounds, that is race, religion, sex, place of birth, descent, and residence. Place of birth, descent, and the residence. Descent and the residence. That means Article 16, Article 16, Article 16, Article 16 deals with Article 16, clause 1 and clause 2 deals with non-discrimination, that is equality, non-discrimination of the individuals, non-discrimination of the individuals on certain grounds, those grounds. What are those grounds? One is race. One is the race, religion, race, caste, sex, descent, place of birth, and residence. Place of birth and the residence, or any of them, or any of them, or any of them, by any of them in the matters of the public employment, any of them in the matters of the public employment. Whereas Article 16, Article 16 plus 3, Article 16 plus 3, Article 16 plus 4, Article 16 plus 5, Article 16 plus 5, Article 16 plus 5, where Article 16 plus 3 deals with exemption to the above, exemption to the above, exemption to the above for certain classes of the citizens, for certain classes of the citizens, certain classes on the basis of domicile, on the basis of domicile. For example, it was the reservations for the residents, reservations for the residents of Hyderabad, reservations for the residents of the Hyderabad under the Mulk laws, under the Mulk laws for the class 4 appointments, for the group 4 appointments in Andhra Pradesh, in the Andhra Pradesh. Article 16 plus 3 plus 4 plus 5 on the classifications for conferring special privileges, classification for conferring the special privileges for the certain social groups. Article 16 plus 3 வந்து domicile. Resident citizens காக சில ஸ்பெஷல் privileges. அப்போ ஆந்திர பிரதேஷ் இணைஞ்சப்போ ஆந்திர பிரதேஷ்ல ஹைதராபாட்ல இருந்த ரெசிடென்ட்ஸ் கிளாஸ் 4 ஹைதராபாத்ல இருக்கிற ஜாப் எல்லாம் அவங்களுக்கு மட்டும்தான் ஒண்ணு இருந்தது. அதை அவங்க பின்னாடி ஃபாலோ பண்ணல. அதனாலதான் பிரச்சனைங்க அதை விடுங்க. ஆர்டிகல் 16 கிளாஸ் 4 வந்து conferring articles in the class 3, class 4 and class 5 were all deals with the doctrine of protective discrimination. Doctrine of protective discrimination. Doctrine of protective discrimination. That means the protective discrimination by reasonable classification. Reasonable classification of the individuals. Reasonable classification of individuals are woman, children, depressed classes, that is SC and ST, then socially and educationally backward classes, then economically weaker sections, to have the special privileges, the special privileges in the form of reservations, in the form of the reservations. That means the reservations for SCSTs, the reservation for the SCSTs for 17% in the public employments, the reservations for the socially and educationally backward classes. Who are those socially and educationally backward classes? In which the Supreme Court, in the case called as Balaji versus State of Karnataka case. Balaji versus State of Karnataka case, where Supreme Court has stated Balaji versus State of Karnataka case, in which socially and educationally backward classes belongs to certain caste communities of backwardness, and the Balaji case, in which Supreme Court states that the caste should not be the only criteria. Caste should not be the only criteria to categorize into backward classes. But the other criterias include time, geography, the people who are living in the remote areas, geography, then poverty, then also underrepresentation should taken into account to categorize a community into backward classes. Then court also stated a backwardness of the community is not permanent. Is not permanent one, and the state shall review periodically. There should be a periodic review and revision of the backward classes. Then Supreme Court in the Indra Shani versus in the Indra Shani versus Union of India case in 1993, Supreme Court stated that it was called as the Mandal 1 case. It was called as the Mandal 1 case. Mandal Commission பத்தி எல்லாம் தெரியும் இல்லையா? Mandal Commission பத்தி தெரியும் இல்லையா? ஹலோ மண்டல் கமிஷன் 2549 ஜாதிகள் based on 1931 caste census. 1931 caste census, and Mandal Commission recommends 27% reservations. So in Indra Shani versus Union of India case, Supreme Court stated that 27% reservations for other backward classes is valid. Then Supreme Court also stated the reservation shall not exceed in the merit list, shall not exceed in the 50%. And the 50% plus shall exceed in extraordinary condition. Shall exceed in the extraordinary condition. Supreme Court also stated the state can classify most backwardness within the backward classes. Classifying the most backward class communities within the backward class as valid. And court also stated the exclusion of the people coming under the creamy layer. The state shall exclude the beneficiaries coming under the creamy layer. And court also stated that the state shall establish a backward classes commission. State shall establish a backward classes commission. A backward classes commission for periodic revival of inclusion and exclusion of the communities. Inclusion and exclusion of the communities into the list of the backward classes, in the list of beneficiaries of the backward classes. That was the Mandal 1 judgment of the Supreme Court of India. And later, the government of India came out with the economically weaker section, EWS reservations. That is extending 10% reservations for the people belonging to the economically weaker sections. The people belongs to the economically weaker sections. Economically weaker sections on the grounds of economic backwardness. On the grounds of the economic backwardness. For that, there would be an creamy layer exclusion. The beneficiaries are excluded. With the criteria of the creamy layer. In which economically weaker section represents a classification of non-caste. It is the non-caste classification, which includes the peoples coming from the general other communities, and also of other caste. Also of the other caste. புரியுதா? ஹலோ, people coming from SC கூட அதுல அப்ளை பண்ணலாம், OBC அப்ளை பண்ணலாம், OC அப்ளை பண்ணலாம். புரியுதா?
Yes, sir.
OC அப்ளை பண்ணலாம். இடபிள்யூஎஸ்ல போறீங்கன்னா அந்த கிரைட்டீரியா வரணும். அப்போ இந்த கிரைட்டீரியா ஓபிசிஸ் வராது. ஓகே.
Yes, sir.
Okay. So that represents the provisions of Article 16. The provisions of the Article 16. Article 16. Then Article 16, that is Mandal 1 and Mandal 2 case. Mandal 2 case என்ன பிரச்சனைன்னு பார்த்துட்டோம் இல்லையா? இல்லையா? ஹலோ
Yes, sir.
இல்லையா? 9th schedule பார்த்துட்டோம். Then இதுதான் உங்களுக்கு தெரிய வேண்டியது. Then the Article 17. Article 17 that deals with the abolition of untouchability. Article 17 that deals with the abolition of the untouchability. Abolition of untouchability. நமக்கு தெரிய வேண்டியது abolition of untouchability, in which constitution not defining the untouchability. Not defining the untouchability. Untouchability is a practice of social prejudice. Practice of social prejudice existed in the Hindu caste community. The Hindu caste community of alienation and subjugation. Alienation and subjugation of certain members of certain caste groups, members of certain caste individuals in access to public places and public interactions, and public places and the public interactions. For that, Article 17 is in the form of directions to the state, that the state shall take measures to abolish untouchability exist in India. For that, Parliament, state empowers, the Constitution empowers the state to take measures. For that, Parliament legislated abolition of Untouchability Act, two important acts. One is Abolition of Untouchability Act of 1955, called as PCR. PCR, Protection of Civil Rights Act of 1955. Protection of Civil Rights Act of 1955, in which untouchability is stated as an offense. Offense in which specifying the offense, specifying one, specifying justification of the untouchability. Justification of the untouchability. Then desecration of an individual on the grounds of untouchability. Justification, desecration, practice, were all treated as an offense with the penalties. The penalties ranging from 3 to 7 years of rigorous imprisonment, the fine, and also the deprivation of the rights under Article 326. The deprivation of the rights under Article 326, that is right to vote and also right to contest the elections. Right to contest the elections. Then the prevention of atrocities. The prevention of atrocities for scheduled tribes, scheduled caste and scheduled tribes Act of 1988. Scheduled Tribe and Scheduled Tribes Act of 1988 were the two acts that ensures the abolition of untouchability practice in India. Abolition of untouchability as a practice in India. அவ்வளவுதான். அது பத்தி அவ்வளவுதான் தெரிஞ்சுக்கணும். ஓகே ஓகே ஓகேவா? ஹலோ. Abolition. Then Article 18. Article 18. Article 18. Article 18 that deals with abolition of titles. Article 18 that deals with the abolition of titles. Abolition of the titles. The titles of the colonial times. The titles of the colonial times. That is, the colonial times as the Rao Bahadur, Diwan Bahadur. That is Article 18 that deals with the abolition of titles. The titles, the colonial titles that exist in India. The reason is to ensure the equality of status stated in the preamble. There is to ensure the equality of status. So, members of the Constituent Assembly favored the abolition of these titles, favored this abolition of these titles. But the Constitution enables the state to confer certain awards, certain awards of promoting the military awards, the gallantry awards for the excellence and service. That is the military awards as the Paramveer Chakra, Mahavir Chakra of the wartime, military award of wartime. The wartime as Paramveer Chakra, Mahavir Chakra, and Ashok Chakra as the peacetime, as in the non-war period. That is the military award. Then the awards of the civilians, the civilian award, the awards of the civilian. That means one is Bharat Ratna. Bharat Ratna was the highest award. Bharat Ratna was the highest award established by a parliamentary resolution in 1954. A parliamentary resolution in 1954. This established, originally Bharat Ratna was awarded to the individuals for their excellence in art, literature, and science and public service. But since 2011, it is extended to the people of any field of the human endeavor. Any field of the human endeavor. That is the award of the Bharat Ratna. The award of the Bharat Ratna. Bharat Ratna award consists of a certificate, but without any cash. There is no monetary grant. A certificate, then a medal of bronze. A medal of bronze with the image of sun, without no monetary grant with the Bharat Ratna. More monetary grant with the Bharat Ratna. The nomination for the award to be made by any of the state government or the union government. Any of the state government or the union government, or to be represented by any of the member of parliament or to be represented by any of the eminent persons, any of the eminent persons, any of the eminent persons, and and there shall be an advisory committee. There will be an advisory committee which involve in selection for the conferment, and the award of Bharat Ratna shall be approved by the cabinet, the ministerial cabinet, and to be authorized by the President of India. Bharat Ratna awardee enjoys certain privileges. What are the privileges for the Bharat Ratna awardee? The privileges, one is they shall get the pensions. The pensions equal to the salary of the CJI, the salary of the CJI of India. Salary of the CJI of India. Then shall have a discount in travel. Shall have the discount in travel. And shall have the priority. Shall have the priority. And shall be provided, and shall be in the order of precedence. ஒரு மீட்டிங்ல, ஒரு public functionல, the Bharat Ratna award enjoys the seventh rank. President, Prime Minister, Cabinet Ministers, Chief Ministers, Chief Army Staff, Judges, adla seventh. And shall have a state funeral. State funeral with the military, ராணுவ மரியாதை. செத்து போனா, இறந்து போனா ராணுவ மரியாதை. That is the highest award. And Bharat Ratna awardees are the right to claim Z plus security. Right to claim the Z plus security. That is the nature of the Bharat Ratna. So far, Bharat Ratna has conferred to the many one. Recently, government came out with the conferment of Bharat Ratna. யாராருக்கு recently யாராருக்கு கொடுத்தாங்க? யாராருக்கு? Hello. P.V. Narasimha Rao, the former Prime Minister, then Chaudhry Saran Singh, the former Prime Minister, Dr. M.S. Swaminathan, posthumously, L.K. Advani, then Karpuri Thakur, like that, various. There were the foreign citizens who got this award. One is Khan Abdul Ghaffar Khan. L.I. Gandhi Ghaffar Khan. Khan Abdul Ghaffar Khan was the first foreigner to have the conformity of the Bharat Ratna. Then second one is it was the Mother Teresa. Second. Then Nelson Mandela, Mother Teresa, foreigners who got this award. See, this seems to be the award. Apart from this Bharat Ratna, we are having the distinguished services in Padma Bhushan, Padma Shri, as the various awards, in which it seems to raise some questions. These awards are conferring was tagged with the privileges. These awards are tagged with the privileges. Then the second question is, these awards are politically motivated one. Politically motivated. For example, Dr. B.R. Ambedkar, conferment of the Bharat Ratna to Dr. B.R. Ambedkar was only after it was conferred to the our Chief Minister MGR. MGR was conferred with the issue of the Bharat Ratna award. Politically motivated conferment of the special privileges. Conferment of the special privileges that is being against to the spirit of equality of status that made Janata government to dissolve, to abolish all the awards from 1977 to 1980. No awards. Abolish all the awards. But it was reviewed. It was reviewed right from reinstatement of the Congress government since 1980. It was reviewed with certain conditions. One is, this award should not use as prefix. The prefix to no award should be used to as the prefix to certain names. புரியுதா? உள்ள பட்ட பேரா அதை யூஸ் பண்ணக்கூடாது. Prefix or suffix, பட்ட பேரா யூஸ் பண்ணக்கூடாது. Second one is, this should not be conferred with any privileges of the state. Any privileges of the state. Any privileges of the state. Conditions. These conditions, since these conditions have no law, backed by no law. No law was tagged with அத மீறினா என்ன, அத மீறினா தப்புன்ட்டு எந்த லாவும் இல்லை. There is no law of prohibiting these conditions. These conditions still exist. இப்போ நீங்க துர்காதாஸ் பாசு புக்கை எடுத்து பாத்தீங்கன்னா, புக் இருக்குல்ல, துர்காதாஸ் பாசு புக்கை எடுத்து பாத்தீங்கன்னா, ஆத்தர் பேரு என்ன சொல்லுது? ஆத்தர் பேரு பத்மபூஷன் துர்காதாஸ் பாசு தான் போட்டிருக்காரு. Because there is no law prohibiting no law, since there is no law prohibiting these conditions, enforcement of these conditions, it has been existing in India as a practice. Okay wow.
Yes, sir.
Existing in India as a practice. இந்த பாரத நந்தலால் போஸ் இத வந்து வடிவமைச்சாரு. இது பிரான்ஸ், சூரியன் இருக்கும், பிரான்ஸ். ஓகே, 2011 இருந்து தான் எல்லாருக்கும் கொடுத்தாங்க. அதுக்கு முன்னாடி சர்டன் சர்வீசஸ், ஆர்ட், லிட்டரேச்சர், பப்ளிக் சர்வீஸ் அன்ட்டு இது கொடுத்தாங்க. 2011 தான் மேலதான் ரொம்ப பேருக்கு இது கிடைக்குது. ஓகே, இதுக்கு கண்டிஷன் என்னன்னா, எந்த இதுவும் யூஸ் பண்ணக்கூடாது. 2 கண்டிஷன். ஒண்ணு வந்து இது ப்ரிஃபிக்ஸ், இது பட்டப்பேரா யூஸ் பண்ணக்கூடாது. எந்த ஒரு சலுகைகளும் யூஸ் பண்ணக்கூடாது. அதுக்கப்புறமா இந்தியன்ஸ் வந்து ஃபாரின் அவார்டு வாங்கக்கூடாது. கவர்மெண்ட் பர்மிஷன் இல்லாம ஃபாரின் அவார்டு வாங்கக்கூடாது இந்தியன்ஸ். அந்த கண்டிஷன்ஸ் போட்டாங்க. பட் இது அந்த கண்டிஷன்ல இந்த கண்டிஷனுக்கு வந்து எந்த சட்டமும் இல்லாதவங்க எல்லாம் யூஸ் பண்ணி, ஓகே, பட்டப்பேராவே யூஸ் பண்ணி. ஓகேவா? ஓகே, தென் Article 19 that deals with the rights to individual freedoms. இது முக்கியம். Right to individual freedoms. Right to individual freedoms. Right to individual freedoms. Article 19 is the part of the golden triangle of the fundamental rights. Golden triangle for the fundamental rights. These rights, right to individual, is the core of the part 3 of the Constitution. These rights are the democratic rights. These rights are the democratic rights. These rights are democratic rights, which is essential for a decent standard of life, which is essential for the decent standard of life in India. So these rights constitutes the spirit of human right. These rights are democratic, and these rights constitutes the spirit of the human right, because these rights enable the state of India is a democratic one. And these rights are essential because only these rights enable the state of India as a free and fair society. These rights are essential for the existence of a free and fair society in the state of India. Free and fair society in the state of India. The significant aspect of Article 19 is Article 19 represents the content of Article 19 is important for the test of classifications. The test of classifications. The test of classifications that comes under Article 14 and 21. Article 14 and 21. Any right under Article 21 and Article 14 should be made only in the context of the rights under Article 19. Only in the context of the rights under the Article 19. But the rights under Article 19 is not absolute. It's not absolute. It are not absolute. It constructs a balance. It constructs a balance between individual rights and social control. It constructs a balance between the individual rights and the social control. Balance between the individual rights and social control comes under Article 19 plus 2. Article 19 plus 2, in which that deals with the reasonable restrictions. That reasonable restrictions, நியாயமான தடைகள். இந்த சொல்லப்பட்ட எல்லா உரிமைகளும் தடையில்லா உரிமையில், எல்லா உரிமைகளும் தடையில்லா உரிமை. அரசு சில தடைகளை போடலாம். Reasonable restrictions on the grounds of defamation. On the grounds of defamation on the grounds of defamation. மத்தவங்கள கேவலமா பேசுறது. இந்த ராகுல் காந்தி பேசுறது. On the grounds of defamation. Then unity and integrity of the state of India. Then unity and integrity. Then interest of sovereignty and integrity of the state of India. Then security of the state. Friendly relations with the foreign countries. to secure public order based on decency and morality. To secure public order based on the decency and morality. எல்லா மோடிங்களும் திருடங்களா இருக்காங்க. அது democratic standards, decency and morality அடிவாங்க. அந்த மாதிரி பேசணும். Then in relation to the contempt of court, நீதிமன்ற அவமதிக்கிறது. Inciting offense, adra, நீதிமன்றங்கள் அவமதி. So these are all comes under the reasonable restrictions. Supreme Court defines what is reasonable. What is reasonable? The court defines reasonable means it is reasonable. It should not be arbitrary. Not be arbitrary. எதாச்சுக்கார் உன் இஷ்டமா தடைங்களை போடுறது. Not be arbitrary. It should be reasonable. Then second, it should be specific. It should be specific. ஒரு தடையை நீ போட்டீங்கன்னா ஸ்பெசிபிக்கா எதுக்காக? Not of generalized and mixed up and mix up. Not of generalize and mix up. புரியுதா? ஒரு தடையை நீ போடுறீன்னா ஸ்பெசிபிக்கா இருக்கணும். பஞ்சு மிட்டாய் சாப்பிட்டா பஞ்சு மிட்டாய் மேல விக்கிறது ஒரு தடை. ஓகே, கடையில தள்ளிட்டு வர்றதெல்லாம் விற்க கூடாதுன்னு போட முடியாது ஜெனரலா. புரியுதா? ஹலோ, பஞ்சு மிட்டாய் விற்கிறது ஒரு ஸ்பெசிபிக்கா இந்த காரணத்துக்காக போடணும். இதுக்காக பஞ்சு மிட்டாய் டைப்ல இருக்கிறத எல்லாத்தையும் நான் தடை பண்றேன்னு. இட் ஷுட் பி ஸ்பெசிபிக். It should not be arbitrary. சும்மா நிறைய தடை இனிமேல் இதெல்லாம் விற்க கூடாதுன்னு சொல்லக்கூடாது. அதுக்கு ஒரு நியாயம். அதான் ரீசனபிள். It should be made that without that should be no alternate. அந்த தடை தவிர வேற வழி இல்லைன்னா தான் நீ தடையை போடணும். புரியுதா? அந்த பஞ்சு மிட்டாய் விற்கிறத தடுக்க வழி இல்லைன்னா தான் நீ தடையை போடணும். If there is no alternate, and that it should have a free and fair procedure. Free and fair procedures. இதெல்லாம் பாத்துக்கணும். ஏன்னா சப் ஆப்ஷன்ல கொடுப்பான். புரியுதுங்களா? It should be a and fair procedure. What is that free and fair procedure? Free and fair procedure should be a procedure. Free and fair procedure should be an opportunity to represent. இப்ப மோடி வர்றதுக்கு ஷோக்கு 5 கிலோமீட்டர் ஷோக்கு தடை போட்டீங்கன்னா அப்ப இது அந்த தடையை மீறி இப்ப தடைக்கு நீ என்ன தடை என்று அவன் ரெப்ரசன்ட் பண்றதுக்கு நீ கொடுக்கணும். ஓகே, should be opportunity of procedure. Then opportunity for the aggrieved to represent. Then that free and fair, that procedure should fulfill the principle of natural justice. The procedure should fulfill the principle of natural justice. The principle of the natural justice. Okay. The procedure should fulfill the principle of the natural justice. இப்ப procedure, elections model code of conduct வந்துடுச்சு. procedure நீ பணம் கொண்டு வந்தா புடிச்சிடறாங்க. அப்படியே புடிச்சிட்டு சீஸ் பண்ண முடியாது. எதுக்காக பணம் வந்தது, எதுக்குன்ட்டு விலாவரியா விசாரிக்கணும். அவருக்கு ஆப்பர்ச்சுனிட்டி கொடுக்கணும். இப்ப பணம் எடுத்துட்டு வந்தவங்களுக்கு ஆப்பர்ச்சுனிட்டி கொடுக்கணும். அது ஃபேரா இருக்கணும். Principle of the social justice. Then that procedure should have a nexus between objective sought to be achieved and the framework of the procedures. Objective, a rational objective, a rationality of the objective. Classifications மாதிரி rationality. இதெல்லாம் இருக்கணும் அந்த ப்ரொசீஜர். அந்த ப்ரொசீஜர் that is called as reasonable. These are all test of reasonable. புரியுதா? These are all the test of reasonable. There should be a test of reasonable. By that the two comes under certain grounds. This reasonable restriction is the part of the part 3 of the Constitution. Bill of Rights of the US don't have this specified grounds of reasonable restriction. புரியுதா? நம்ம பில் ஆஃப் ரைட்ஸ் அப்படியே எடுத்துக்கினாலும் ஃபண்டமெண்டல் ரைட்ஸ்ல அதுக்கும் நம்மளுக்கும் வித்தியாசம் இருக்கு. ஃபார் எக்ஸாம்பிள் ஆர்டிகல் 17 நாங்க இல்ல. அப்போ ஆர்டிகல் 19 clause 2 ரீசனபிள் ரெஸ்ட்ரிக்ஷன் யூஎஸ்ல இல்ல, இந்தியன் கான்ஸ்டிடியூஷன்ல தான் இருக்கு. புரியுதா? These rights are not absolute. And these rights were subjected to reasonable restrictions. That restrictions, Article 19, specifying the grounds of the restrictions. And the grounds of restrictions, while enforce, on the grounds enforce பண்ணும்போது, there should be a test, reasonable. Reasonableக்கு ஒரு டெஸ்ட் இருக்கு. ஒரு டெஸ்ட் ரீசனபிள், டெஸ்ட் ஆஃப் ரீசனபிள், தட் இஸ் ஆர்பிட்ரரியா இருக்கக்கூடாது, ஜெனரலைஸ்டா இருக்கக்கூடாது. ஆல்டர்னேட் அந்த ப்ரொசீஜர் எப்படி செயல்படுத்துறோம், அந்த ப்ரொசீஜர் ஃபேர் ப்ரொசீஜர். A fair procedure means it should fulfill the principle of natural justice. ஓகேவா? Okay, this is the Then what are those rights? First one is Article 19, Clause 1, Subclause A. Enna right there? What is this right? Right to speech and expression. Right to speech and expression. Right to speech and expression is the fundamental right. And the right enna soludhu? That means an individual, any citizen of India has the right to express whatever he feels and concise of opinion. A concise of opinion through any medium of communication. So right to freedom of speech and expression. That means a right of individual to express himself, express an individual opinion through any medium of communication, in which the Supreme Court observed even the silence is a form of fundamental rights under right to freedom of speech and expression. Fundamental rights under the right to freedom of expression. Silence is a form of fundamental right. Right to freedom to express means right to information. It is the right to information as the fundamental right. Right to inform others. Right to communicate means right to inform others is the fundamental right. Right to educate others is the fundamental right. Right to broadcast is the fundamental right. Right to inform others means The right to inform others means the right to inform others is the fundamental right that comes under the freedom of press. Freedom of press is a fundamental right that comes under Article 19, Clause 1, Subclause A. Article 19, Clause 1, Subclause A. That means freedom of press. Freedom of press is the fundamental right for the press in India. Fundamental rights for the press in India. The fundamental rights for the press, by that the press enjoys the freedom. The press enjoys the freedom of information and education, educating the public, educating the public, that the press enjoys the freedom from the arbitrary role of the state. Arbitrary role of the state. That means the press enjoys the freedom from the arbitrary act of Caesar, curtailment of publications, இதெல்லாம் colonial periodல நடந்தது. Curtailment of publication, then abolition of licenses, curtailment of publication or circulations, curtailment of publication or the circulations, and also singling out of a particular press in regard to taxes and all. But the freedom of press is not amounted to. The freedom of press is not extended to the press. Press has no immunity. Has no immunity from the industrial laws. No immunity from the industrial laws or the labor laws. So press has no immunity from taxation. Press has no immunity from the taxation. And press is subjected to the censorship. Press is subjected to the Censorship Act is applicable to the press. Taxation laws applicable to the press. Industrial laws are applicable to the press. Industrial laws are applicable to the press. Censorship Act of India. Censorship Act of India is of the pre-colonial one. Pre-colonial Act. The pre-colonial Act. It was accepted by the member of Constituent Assemblies. The member of Constituent Assembly, in which the Censorship Act can be enforced. Censorship Act can be enforced even at the time of peace. Even of the time of peace under reasonable restrictions of Article 19, Clause 2. Under the reasonable restrictions of the Article 19, Clause 2. Article 19, Clause 2. Okay. Reasonable restrictions of under the Article 19, Clause 2. Now, the right to informations deals with the three aspects. three aspects of the informations. One is right to inform others includes right to know information, right to get informed information, right to inform others, right to information deals with the three aspects. One is right to inform, right to inform others. That means which is a corollary to right to get the information, right to get the information, right to get the information, right to have information. Right to have information comes under Right to Information Act. Right to Information Act of 20, Right to Information Act, Right to Information Act of 2005, Right to Information Act of 2005, Right to Information Act of 2905 that deals with the right to have information as a fundamental right. A fundamental right, as any citizen of India is conferred with the right to have information on the government records. The Right to Information Act establishes Right to Information Act of 2005. 2005 establishes a procedure. That means an individual should have the information from the public domain with the 30 days of his application, and any information on the right to liberty, should be provided within 2 days, within 48 hours. Then every department of the state should have a public information officer, to provide the service of information demanded by the citizens. That is, the information includes file notings. The information includes the file notings. That is the opinion of concerned officers. Act establishes an information commission as the Central Information Commission, and every state should have their own information commission with the chief information commissioners. Act enabled the individual to go for appeal with the denial of the information to the information commissioner. Act also establishes certain exemptions to have the information. What are the exemptions? The exemptions in regard to the informations that affect sovereignty and integrity of India, the exemption that it was forbidden by the rule of court of law and tribunals, then the exemptions of any information dealing with the privileges of parliament and the state legislature, the exemptions in regard to the intellectual property rights, the exemptions on any matters that comes under Article 71, that is the Council of Ministers recommendations. Then the exemptions that comes under the exemptions of government agencies that was specified by the Act in the second schedule as CBI, NIA, national security, government agencies, of police, government agencies. Then exemptions, the exemptions that in regard to fiduciary relations, exemptions in regard to the fiduciary relations. Fiduciary relations, that means the relations of the individual with the particular state. The individuals with the particular state. இப்போ உதாரணமா ஒரு தாசில்தார் மேல ரைட் டு இன்ஃபர்மேஷன் ஆக்ட் கேட்டாங்க. அந்த தாசில்தாருடைய குவாலிஃபிகேஷன் என்ன கேட்டாங்க. அவரு சொல்லிட்டாரு, இட் இஸ் இது என் குவாலிஃபிகேஷன்ன்றது எனக்கும் டிஎன்பிஎஸ்சிக்கும் சம்பந்தமானது. அது நான் உங்களுக்கு எல்லாம் தர தேவையில்லை அன்ட்டு சொல்லிட்டாங்க. That is any information that deals with the fiduciary relations. The fiduciary relations of the individual and the state were all exempted. Were all exempted under article under the Right to Information Act. Okay. 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 Hello.
Yes, sir.
Hello. Right to Information Act. So same.
Yes, sir.
Then right, the extension of Article 19 clause 1 subclause A deals with the issue of community surveillance, communication surveillance in India. Communication surveillance. Communication surveillance. For example, Pegasus issue. Communication surveillance in India. Communication surveillance. Surveillance is already exist in India in the Indian Telegraph Act. Indian Telegraph Act. Communication surveillance means the state authority of surveillance. What state authority of surveillance in the communications. Indian Telegraph Act, in which the state authority to intercept the communications, then the communications of phone, then the Information Technology Act, the Information Technology Act of 2000, Information Technology Act of 2000, that empowers the state to intercept any communication, in the state of India. Any communication in the state of India. The communication surveillance is the right of the state. The right of the state that comes under the reasonable restrictions under Article 19 clause 2. Reasonable restrictions under Article 19 clause 2. Article 19 clause 2. The reasonable restrictions. So that is the communication surveillance in India. Article 19 clause 1. Article 19 clause 1 subclause A. Article 19 clause 1 subclause A, that led to regulations of the electronic media. The regulations of the electronic media, which was legislated in the Information Technology Act. Information Technology Act of 2000. Information Technology Act of the 2000. Information Technology Act of 2000, which regulate the intermediaries. We regulate the intermediaries. Intermediaries are service providers and social media platforms. Service providers and social media platforms. That is Facebook, Google, social media platform. Act, Information Technology Act. Information Technology Act as the important provisions important provisions. That means Information Technology Act represent a legal obligation of obligations of the privacy for service providers. Intermediaries should ensure the right to privacy of password and electronic signature. Privacy of password and electronic signature. It comes under the fundamental rights as the right to privacy. Right to privacy. Right to privacy. Then Information Act of 2000. Information Act of 2000 represents the penalties of violating the right to privacy. Penalties of violating the right to privacy. Then penalties of violating the right to privacy. Then penalties also for publishing absence materials. That means sexual scenes, diabolical scenes, absence materials in the public. Then section 69A. Section 69A of the Act. Section 69A of the Act enables the authority of the state to issue directions to block any informations for public access. Any information for the public access. Public access. That means any of the union government, any authority of the union government or the state, any authority of the union government of the state can issue directions to the service provider to block any informations from the public access, stating the grounds of reasonable restrictions under Article 19 Clause 2. Then it should follow certain procedures. That means it should be in the form of directions in writing. Directions in writing to the service providers. Directions in writing to the service providers. Provider. And it should have the direction should be given by certain authorized authority, not less than the levels of the Home Secretary, or certain authorized authority, and it should be in the form of writings stating the grounds of directions. So this seems to be the important provisions of the Information Act of 2000, and article that comes under the Article 19 Clause 1 Subclause A. Clause 1 Subclause A. Then the second one is the second of the right. Article 19 Clause 1 Subclause B. That is freedom to assemble peacefully without arms. Freedom to assemble peacefully without arms. Freedom to assemble peacefully without arms. Forms that can be that represents the act of that represents the fundamental right. The right includes the right to processions, right to conduct public meetings, right to conduct the processions, but subjected to the reasonable restrictions. Subjected to the reasonable restrictions. Then freedom of all, then Article 19 clause 1 subclause B, that deals with the freedom to form associations. Freedom to form associations. Freedom to form associations, extending the fundamental right to establish trade unions, the fundamental rights to establish political parties, the fundamental rights to establish the trade unions, fundamental rights to establish the political parties, that is Article 19, clause 1, subclause C, that is the freedom to form associations. The freedom to form associations. That means the right to form the political parties. The right to form any of the trade unions. The right to form any cultural associations. But these rights are not extended from the uniform. The right to form association, trade unions, not extended for the uniform services. And these rights are subjected to the reasonable restrictions under Article 19 clause 1, Article 19 clause 2, in which recently the PFI, SIMI, then the Zigadi terror organizations, then Maoist organizations, People's War Group, were all banned on the grounds of reasonable restrictions. Okay? Hello.
Yes, sir.
Okay. Then Article 20. Article 20 is the fundamental right in respect to convictions for certain offenses. One is convictions for certain offenses. Article 20 and 21. Article 20 and 21, where those provisions were not suspendable in India, even in the course of emergency, in the state of India. Article 20 deals with the three grounds, safeguards of three grounds. One is the ex post facto law. Law. Then double jeopardy. இதெல்லாம் தெரிஞ்சிருக்கும்ல உங்களுக்கு. Double jeopardy. Then that is the right against self incriminating evidence. இதெல்லாம் தெரியும் இல்லையா உங்களுக்கு? Hello.
Yes, sir.
Self incriminating evidence. right against the self-incriminating evidence. Ex post facto law, which means enacting a law and giving retrospective effect. Enacting a law and giving retrospective effect. Giving retrospective effect to that law. Act states that no individuals shall be convicted for the offense, for the act he committed at that time. It was not considered as offense in the law. No individual can be convicted of an act which was not considered as an offense in the law. Not considered as an offense in the law. That is called as retrospective effect. Retrospective effect of the law. But this retrospective effect of the law is not extended. It is only for criminal laws. Only for the criminal laws, not for the civilian laws. Okay. Not for the civilian laws. Then double jeopardy. In principle, double jeopardy means which means penalizing an individual. One is punishing an individual. Punishing an individual for twice. Punishing individual twice for the same offense. For the same offense. That is the double jeopardy. But double jeopardy is not of penalizing the individual. It's not of penalizing the individual. Penalizing the individual for the consequence of the offense, as a consequence of the offense. As a consequence of the offense. A minister who was penalized, for the corruption is prohibited to hold office under Representation of People's Act. That means an individual who was penalized for an offense can be penalized again as the consequence of the offense. And it was not a bar of any departmental action. Any departmental action on individuals as the consequence of the offense that he committed. As the consequence of the offense he committed. An individual who was arrested, who was penalized under the Dowry Act can be dismissed from his office. An individual who was penalized from the Corruption Act can be dismissed from the office that is holding the corruption, holding the office. That is double jeopardy. Then the fundamental right against the self-incriminating evidence. No individual shall subject it to give evidence on his own. Our evidence, be it as a documentary evidence or the physical evidence. An individual should not subjected to compel him to come out with the evidence of himself. But this safeguard is not extended to the cooperation of an individual. This is not amounted to the immunity for individual to cooperate. An individual who is accused should cooperate in the form of providing providing the search seizure of the documents, documental evidence, the physical evidence as the fingerprints and all. But the Supreme Court states that this provision of the cooperation is not the extent to narco analysis on the individual. Narco analysis means the individual is subjected to the seductive chemicals. Sodium pentothal ஒரு sodium pentothal ஒரு drug கொடுத்துட்டு அதுல என்கொயரி பண்றது. ஓகே ஹலோ
Yes, sir.
ஓகேவா?
Yes, sir.
The Supreme Court state applications of narco analysis without the consent of individual, without the individual consent, is a violation of Article 20. This violation of Article 20. That is Article 20 as the violated. That, and the second one is this evidence of this narco analysis. This evidence of the narco on the kelvikala it cannot be treated as not to be treated as an evidence. Not to be treated as an evidence. Purida. Not to be
Yes, sir.
treated as evidence. Not to be treated as evidence. அப்போ சொன்ன பதிலுங்கெல்லாம் அவன் குற்றத்தை ஒத்துக்கினான்ட்டு எடுத்துக்க முடியாது. அவனுடைய கன்சென்ட் இல்லாமையும் பண்ணக்கூடாது. That is the arrest. That is the safeguard. So it is the safeguard against the convictions. That is the safeguard against the convictions. The safeguard against the convictions or later well established by the Supreme Court. Well established by the Supreme Court in D.K. Basu. In D.K. Basu case. D.K. Basu versus State of West Bengal case, in which the Supreme Court came out with the 12 guidelines. 12 guidelines. Number 22 பார்க்கும்போது வந்துரும். 12 guidelines to substantiate the principles of Article 20, 21 and 22. 12 guidelines. That is the aspect of the Article 20. இதுல ரொம்ப முக்கியமா நமக்கு தெரிய வேண்டியது Article 21 of the Indian Constitution. இதுதான் முக்கியம். Article 21 எல்லா எக்ஸாம்லயும் நம்ம வாழ்க்கை. Okay. Article 21 called by the Supreme Court as the heart and soul of the Indian Constitution. Heart and soul of the Indian Constitution. Article 21 shall not be suspended in the state of India even in the course of emergency. Article 21 நமக்கு தெரிய வேண்டியது. That is the provision. The provision of Article 21 deals with right to life and the personal liberty. Right to life and personal liberty. Right to life and personal liberty. That means the article states no individual is denied his right to life and personal liberty without the procedure established by law. That is judicial interpretation of Article 21. இது ரெண்டு தெரிஞ்சா போதும். Judicial interpretations of the Article 21, then significance. இது மூணுல தான் எல்லாம் கொஸ்டின் இருக்கும். The judicial interpretations of Article 21, in which the Supreme Court observes that Article 21 states that no individual is denied from his right to life and personal liberty without the procedure established by law. Without the procedure established by law. That was applied by the Supreme Court. In A.K. Gopalan case. In A.K. Gopalan case, in which the Supreme Court, in 1955, Supreme Court, A.K. Gopalan versus State of Madras, in 1955, Supreme Court applies this doctrine of procedure established by law. இதெல்லாம் தெரியுமா? Hello? The procedure தெரியுமா?
No, sir.
இல்ல சார்.
The procedure இது கட்டாயமா தெரியணும். The procedure established by law. Procedure established by law means சட்ட வரையறுக்கப்பட்ட தத்துவம், சட்டத்தின்படி தத்துவம். The doctrine of procedure established by law was actually the doctrine of United Kingdom, in which the Supreme Court scrutinizes any act of an executive, any executive action, whether it fulfills the procedures stated by the law, whether it fulfills the procedures stated by law, the procedures established by the law. Any executive action of denying the right to life and personal liberty, as it is stated in the procedures of the law. For example, you say Indian CRPC, Criminal Procedure Code, Section 144 of the Criminal Procedure Code. Section 144. Election aniki Section 144 vandrum. Okay. Section 144, if a person arrested by Section 144, Section 144 has certain procedures. One is, it has to be promulgated only by the authority not less than Commissioner of Police. Not less than the Commissioner of Police. That Section 144 shall arrest any individuals who assembled in public places. Means it should have the procedure. Assembly means there should be at least 4 persons. There should be at least 4 persons. And it should be a public procedure, public place. It should be a public place. இதெல்லாம் procedures. புரியுதா? Court would verify. ஒருத்தனை Section 144ல அரெஸ்ட் பண்ணிட்டா ஜட்ஜ் மேஜிஸ்ட்ரேட் பாப்பாரு. இதுக்கு 4 பேர் இருக்குமே, 4 பேர் என்ன? இல்ல சார் 2 பேர் தான் அரெஸ்ட் பண்ணனா, அவ்வளவுதான். Arrest is invalid. If the Section 144 is not promulgated by the Commissioner of Police, Deputy Tahsildar இதான் பண்ணாரு, கையெழுத்து போட்டாரு, இது இல்லைன்னா arrest is invalid because it is not fulfilling the procedure established by law. புரியுதா? இப்போ பப்ளிக் பிளேஸ், நான் என் கடைக்குள்ள சேர்ந்த, நான் என் ஆபீஸ்ல இருந்தேன், நான் வெளியில பப்ளிக் பிளேஸ்ல இல்ல, ரயில்வே பிளாட்ஃபார்ம்ல இல்ல மார்க்கெட்ல இல்ல தெருவுல நின்று இல்ல, என் ஆபீஸ்ல இருந்த, என் ஆபீஸ் வாசல்ல இருந்த என்ன புடிச்சிட்டு போயிட்டான். அது நாட் ப்ரொசீஜர், தட் இஸ் அரெஸ்ட் இஸ் இன்வாலிட். புரியுதா? புரியுதா?
Yes, sir. Yes, sir.
புரியுதா? These are all the procedure. இப்போ procedure include any act of disrupting decency and morality of the public order. இதெல்லாம் டீசன்சி. நாங்க 4 பேர் தான்ப்பா இருந்தோம், ஆனா 4 பேர் அமைதியா உட்கார்ந்து இருந்தோம். நான் டீசன்சி மொராலிட்டி இதெல்லாம் நாங்க இது பண்ணல, அமைதியா உட்கார்ந்தோம். எப்படி என்ன அரெஸ்ட் பண்ணுவேன்? ஆனா பண்ணாது, செல்லுபடி ஆகாது. So court would go, judicial court would go through only the executive action, whether that action fulfills the procedure established by the law. Very important is the court would go through only the executive action, and court don't bother even that procedure, don't bother whatever the procedure it may be, whatever the procedure it may be, whatever the procedure it may be, whatever the procedure it may be. And even if the procedure violates, even if the procedure violates the principle of natural justice, court don't bother. Court would verify only the executive action, called as doctrine of procedure established by law. புரியுதா? புரியுதா?
Yes, sir.
Yes, sir.
அந்த ப்ரொசீஜர் எப்படி ஒரு சட்டம் போட்டாங்கன்னா, அந்த ப்ரொசீஜர் எப்படி இருந்தாலும் எனக்கு அதை பத்தி கவலை இல்லை, மேஜிஸ்ட்ரேட்டுக்கு கவலை இல்லை. சட்டம் பிரகாரம் தான் பண்ணிருக்காங்க. திக் போடு. It violates the principle of natural justice. இதுதான் 1956ல இருந்து the court interpret பண்ணிட்டு இருக்கு. 1956ல இருந்து கோர்ட் இன்டர்பிரட் பண்ணிட்டு. பட் in 1982 ஒரு கேஸ் வந்து called as Menaka Gandhi case. Menaka Gandhi யார் தெரியும் இல்லையா? யாருங்க?
Yes, sir.
Menaka Gandhi versus Union of India. Menaka Gandhi அந்தமா பாஸ்போர்ட்டை புடிச்சு வச்சுட்டாங்க. அப்போ ஒரு கேள்வி வந்தது. கேள்வி என்னன்னா, ஆர்டிகல் 21 ரைட் டு லைஃப் அண்ட் பர்சனல் லிபர்ட்டின்னு சொல்றீங்க, நீங்க இஷ்டத்துக்கு ப்ரொசீஜர் எஸ்டாப்ளிஷ்டு பை லா, கோர்ட் வில் லுக் ஆஃப்டர் த ப்ரொசீஜர் ஒன்லின்னா, அந்த ப்ரொசீஜரே டிரகானியன் ப்ரொசீஜரா இருந்ததுன்னா எப்படி ரைட் டு லைஃப் காப்பாற்றப்படும்? நியாயமான கேள்வி தானே? ஹலோ, நியாயமான கேள்வி தானே அது? If that procedure established by law is violating the right to life, means what is the value of Article 21? By that, the court discovered the doctrine of due process of law. The doctrine of due process. The doctrine of due process from the US traditions, from the US Supreme Court. In that, the Supreme Court shall verify that procedure, even that procedure to the test of fairness, and to the test of the principle of natural rights, the principle of natural justice. The Supreme Court would verify that even that procedure, the procedure should be a fair procedure, and procedure should fulfill the principle of natural justice. Principle of natural justice. By that the court shall verify not only the action of executive, but also the intention of the legislature. But also the intention of the legislature. The intention on the on the fairness of the procedure. The procedure established by the law, Supreme Court has stated the procedures established by law should fulfill the principle, the test of fairness. It should fulfill the test of fairness, should fulfill the test of the natural rights and natural justice. To fulfill the test of the natural justice. Fulfill the test of the natural justice. By that the Supreme Court established Article 21 as the guarantor of, as the fountainhead, as the guarantor of the fundamental rights. As the guarantor of the fundamental rights. It safeguards, the guardian of the fundamental rights, which safeguards not only from the executive action, but also the law of the legislature. But also the law of the legislature. But also of the law of the legislature. That is called as the doctrine of due process of law. Okay? Okay.
Yes, sir.
So, by that, the Supreme Court has transformed this Article 21, the amplitude of Article 21, amplitude of Article 21. The amplitude of Article 21 in the form of right to life. The right to life that was stated under Article 21 is possible only with the doctrine of due process of law. Only with the doctrine of due process and the procedure established by the law. Doctrine of due process and the procedure established by the law. Supreme Court stated, though the doctrine of due process not stated in the article, but it implicitly exists in the right to life. But it implicitly exists in the right to life. Right to life. Right to life. And Supreme Court also stated that the right to liberty. Supreme Court also stated that the right to liberty, the right to liberty, the right to liberty, a right to liberty extending a living entity, a man, right to life, a right to life, or right to life with the right to lively existence should fulfill the right to liberty. And the right to liberty is not confined only to those rights stated under Article 19 Clause 1. Only right to liberty is not limited with the right to the right stated under Article 19 Clause 1. புரிதா? சுதந்திரம் என்பது ஷரத்து 19 உட்ஷரத்து 1 சொல்வது மட்டுமல்ல. Not only the democratic rights, but there are certain rights. Those certain rights that are inferred. Certain rights called as inferred. யூகிக்கப்பட்ட உரிமைகள். Certain rights called as inferred rights. What is that inferred rights? Inferred rights are those rights which are not explicitly enumerated in Article 21 or Part 3 of the Constitution, those rights not enumerated under the Part 3 of the Constitution, but implicitly exist in the state of India and enjoys the status of fundamental rights, enjoys the status of the fundamental rights called as inferred rights. Supreme Court in various cases discovered this inferred rights as the right to privacy, inferred recently in the Puttaswamy case, the Aadhaar case. Right to have clean environment as the inferred rights, as a fundamental right. Right to have the clean environment in the Delhi metropolitan corporation case. Then right to shelter in the Asiad case. Right to shelter in the Asiad case. Right to have a free elementary education in the Unnikrishnan case, as various rights which was not stated in the Constitution, was stated by the Supreme Court, pronounced by the Supreme Court, that it enjoys the status of the fundamental rights called as inferred rights. So Supreme Court expanded the scope of Article 21. The scope of Article 21 has been transformed. Article 21 was transformed completely in amplitude, the way it enforces, and the scope, the way it expanded. So Article 21 now became fountainhead of the fundamental rights. The fountainhead. It now became the fountainhead of the fundamental rights. It is a spring of the fundamental rights. Article 21 is the proxy of human rights, natural rights, and the inferred rights. It's a proxy of the human rights, natural rights, and the inferred rights. So Article 21 represents the heart and soul of the Indian Constitution. Supreme Court pronounces that Article 21 is the heart and the soul of the Indian Constitution. Heart and the soul of the Indian Constitution. Further, Article 21 cannot be suspended. In India at any point of time, and Article 21 gives life to all the fundamental rights in India, all the fundamental rights of the Part 3 of the Constitution. Article 21 is the nucleus of all the fundamental rights. In a case called as habeas corpus case, habeas corpus case. In a case called as habeas corpus case in 1977, habeas corpus case was the case called as Sasikant Shukla versus Sasikant Shukla versus ADM Jabalpur. Sasikant Shukla was arrested by Assistant District Magistrate of Jabalpur, Collector, District Magistrate of Jabalpur, which led to the question Sasikant Shukla was arrested under emergency laws. When emergency was enforced in India, Sasikant Shukla was arrested under emergency laws, which led to the question. Sasikant Shukla immediately applied for habeas corpus, challenging the detention. It led to the question whether an individual arrested under emergency laws, an individual arrested under the emergency laws, an individual arrested under emergency laws has the right to have habeas corpus under Article 32+1. Whether individual arrested under emergency laws has the right to apply for habeas corpus. புரியுதா? ஹலோ, புரியுதா?
Yes, sir.
எமர்ஜென்சி லாஸ்ல அரெஸ்ட் ஆன ஒருத்தருக்கு ஏபிஎஸ் ஆர் கார்பஸ் உரிமை இருக்கா அன்ட்டு ஒரு கேஸ் வந்தது. தட் இஸ் கால்ட் அஸ் ஏபிஎஸ் கார்பஸ் கேஸ். அதுல வந்து சுப்ரீம் கோர்ட் மெஜாரிட்டி ஜட்ஜ்மெண்ட் உரிமை இல்லை அன்ட்டு முடிவெடுத்தது. என்னது? உரிமை இல்லை என்று முடிவெடுத்தது. பட் a dissent judgment given by Justice H.R. Khanna எதிர்த்து கொடுத்தார். H.R. Khanna stated the existence of Article 21 is of non-suspendable. As Article 21 exists as non-suspendable one, which gives life to Article 32+1, which gives life to Article 32+1. So, right to habeas corpus cannot be suspended. Cannot be suspended. புரியுதா? Cannot be suspended even the course of emergency until judgment கொடுத்தாரு. That அப்போ எடுத்துக்கல சுப்ரீம் கோர்ட். ஏன்னா கோர்ட்ல வந்து சீஃப் ஜஸ்டிஸ் இந்திரா காந்தி அப்பாயிண்ட் பண்ணதுதான். அப்போ எடுத்துக்கல. ஃபண்டமெண்டல் ரைட்ஸ் கேஸ் முடிஞ்ச உடனே இந்த மாதிரி ஒரு ஆளு சீஃப் ஜஸ்டிஸ் அப்பாயிண்ட் பண்ணாங்க. அப்போ எடுத்துக்கலாம். 44th Amendment, Janata government, 44th Amendment established Article habeas corpus under Article 32+1 as the status of non-suspendable. The status of non-suspendable. By that, non-suspendable because of existence of Article 21 as the non-suspendable future. By that, Article 21 gives life to all the fundamental rights. Article 21 enable all the fundamental rights to get enforceable and functional. Article 21 is of non-suspendable one, and it is an organic entity. It is ever expanding in its scope, and it ensures the right to life with the amplitude, with the extending amplitude of the doctrine of due process of law, along with the procedure established by the law. By that, Supreme Court states that Article 21 is the heart and soul of the Indian Constitution. Okay?
Yes, sir.
Okay.
Sir,
சொல்லுங்க.
ஜனதா கவர்மெண்ட் 44th அமெண்ட்மெண்ட்ல வந்து ஆர்டிகல் 32 சப் கிளாஸ் 1 வந்து இது பண்ணாங்கல்ல சார், நான் சஸ்பெண்டபிள் சொல்லிட்டு பண்ணாங்கல்ல சார்.
ஆமா.
அதுக்கு ரீசன் மட்டும்
அது ஜஸ்டிஸ் கண்ணா கொடுத்த ஜட்ஜ்மெண்ட் ஆமோதிச்சாங்க.
ஓகே சார்.
ஓகே. ஓகேவா?
எஸ் சார், எஸ் சார்.
இந்த 31-21 மாத்திரம் நல்லா பாத்துங்க. இன்னும் நம்ம பின்ன கவர்னன்ஸ்ல ரொம்ப நல்லா பார்ப்போம். ஓகே. ஓகேவா?
எஸ் சார்.
Okay, sir.
இது டியூ ப்ராசஸ் ஆஃப் லா எல்லாம் எடுக்கல உங்களுக்கு?
டியூ ப்ராசஸ் ஆஃப் என்னன்னு மட்டும் எக்ஸ்பிளைன்
எடுக்கலையா?
டியூ ப்ராசஸ் ஆஃப் லானா என்னன்னு மட்டும் எக்ஸ்பிளைன் பண்ணாங்க சார். பட் ஆனா இவ்வளவு கிளியரா எடுக்கல சார்.
இப்படித்தான் தெரியும். அப்பதான் நீ அப்ளை பண்ண முடியும். ஓகே ஓகே
ஓகே
ஆ
சார்.
எஸ் சார்.
ஓகேவா? ஓகே. இது போர்டு வேணுமா, வீடியோ வேணுமா, ஏதாவது வேணுமா?
வேணும் சார், ரெண்டுமே வேணும் சார்.
போர்டு 2 பல்ஸ் வந்து இந்த ஈரத்துல பட்டு இதாயிடுச்சு. இதை இப்ப நான் அனுப்பிடுறேன். ஓகே, ஈவினிங் அனுப்புறேன். ஓகே, ஈவினிங் ஹிஸ்டரி பார்த்துலாம் அருண்.
ஆ எஸ் சார்.
ஓகே
சார்
Okay.
டைமிங் சார்.
அதான் 5:30 ஆரம்பிக்கலாமா? 5:30.
சரிங்க சார்.
எது ஆரம்பிச்சாலும் 7:30 முடிச்சிடுறேன். நீ 7:30 தானே கேட்ட?
எஸ் சார். சார் 6 o'clock பண்ணிக்கலாமா சார்? 6 to 7:30. ஓகே
6 to 7:30. ஓகே ஓகே ஓகே.
ஓகே
மெசேஜ் போட்டுரு, இதுல 6 to 7:30 போட்டுரு.
ஓகேங்க சார்.
అవును. ஓகே
எஸ் சார்.
Okay.
கிருஷ்ணா கன்ஃபார்ம்.
ஓகே ஓகேன்பா. இது இப்ப ஒன்னும் நீங்க படிக்க கூட தேவையில்ல, இதையே பாத்துங்க. இந்த ஸ்லைட்ஸ் அமிச்சாச்சு இல்லையா? இந்த ஸ்லைட் அமிச்சிட்டேன் இல்லையா? இந்த ஸ்லைட் அமிச்சேன் இல்லையா உங்களுக்கு? சார் நான் திருப்பி ஒன்னு அனுப்பி விடுறேன். இது உள்ள இருந்து தானே எடுத்தேன், நான் அனுப்பிச்சிருக்கேன். ஓகே,
எஸ் சார். பார்ட் 3 சென்ட் பண்ணுங்க.
பார்ட் 3 மாத்திரம் இன்னொரு கிளாஸ் 21ல இருந்து 22 இதுல இருந்து இன்னொரு கிளாஸ் போகும் பார்ட் 3. அப்புறமா எல்லாமே ஒரே ஒரு கிளாஸ் தான், கடகடன்னு போயிடும். ஓகே
எஸ் சார்.
ஓகே, பண்ணிடலாம். ஒண்ணும் நீங்க இதை மட்டும் பாருங்க. கிளாரிட்டி தான் முக்கியம் கான்ஸ்டிடியூஷன்ல. ஓகே ஓகே, நான் க்ளோஸ் பண்றேன். ஓகே
ஓகே சார். ஓகே சார். தேங்க்யூ சார்.
தேங்க்யூ.